All right, thank you. And Adam, thank you again. We couldn't do this without you. I hope you guys at IHFRA realize that we have really one of the best and brightest legal minds that's working with IHFRA. And I say that not to be gratuitous because I know from whence I speak. Today's topic is contracts. Contracts are nothing new, but they're becoming front and center because we've had more and more conversations from reps explaining they're having some difficulties with lines being pulled, maybe unfair termination, which all circles back to the need for a good and equitable contract. Without further ado, I'm going to turn it over to Adam Glazer, and he is going to talk to us about contracts.
Good afternoon, everybody. Ray, thank you very much. I really would appreciate if you could share some of that best and brightest stuff with my wife. She needs to hear that from you. It would be much appreciated.
Will do.
All right. We got a lot to talk about today, and I do want to get started. So let me take you through this discussion today. We got my contact information in front of you. Of course, our website is nationalsalesrepattorneys.com, where you can find out more information and ask any. There's abilities there to get a hold of us as well. But do let me get started if it's okay. I would like to go through a number of different rules that are going to apply. Now, what I intend to do, and let me just make sure that that I have the right screen up. Steve, can you just nod your head? Tell me, are you looking at the same screen as before? Are we in the right place?
Yeah, that's just kind of the general title screen. How about that?
Okay, good. All right, so thank you for that. Okay. We're going to review some sample contract terms. Some of them are very good, some of them are awful. I can tell you that all of them are plucked out of genuine rep contracts that have been sent to my office and that we have been asked to review. But before we get to the rep provision, the contract provisions, I do want to see what I can do to make this happen here. There we go. I do want to discuss some basic rules with you. When you receive a agreement from a principal, from a supplier, there are 4 rules that govern as far as we're concerned. The very first rule is something that many of us never do, of course, is to actually go through it and read the agreement. I can't tell you how many times I get called and they say to me, Adam, I just got terminated. Am I entitled to anything as a result? I've worked for this supplier for 25 years. And I say, well, I'm going to want to read your agreement. Agreement. Oh, yeah, there was an agreement. And that's what leads to dusting it off if they can find it and reading it for the first time. Not good enough to read it for the first time. You got to read it when you get it. You have to understand what you're signing up for. In fact, of the 4 rules that we have, this rule is so important. I repeat it. You got to read the agreement. It's essential. Then you want to consider whether you can live with or improve what amounts to an opening offer. Companies are going to send you a form agreement. We all know their form agreements. We all know the theory, and the overriding premise is that this is our agreement. Why are you bothering to suggest changes? No other rep has ever wanted to change it. It's an agreement. It's what we've always used. Well, you'll see that just because it's been used that way before doesn't mean that they're unwilling to consider making changes. You have the opportunity now, before you sign the agreement, to negotiate it. That's what you do for a living. That's what sales reps are about. You want to exercise that right while you still can, not when it's too late. And you're asking yourselves, well, what principal is actually going to negotiate, right? Does Adam know any better? Why would a principal negotiate? So consider a few reasons for that, of course. I can tell you from experience that what starts out as a form contract where reps are made to feel that if they don't sign it, the principal will get another rep who will sign the agreement. That's a negotiating strategy. Oftentimes it's a ploy. Many can and are willing to change the form agreement because they want you for a reason. They want you, actually, some principals actually believe that this should be a partnership. They want you vested in the relationship. There's a reason why they're talking to you after all, right? They could have talked to a different rep, but they want you when they send you a contract. So part of that, it's because of your skills as a negotiator and your ability out in the field. Consider how they want you now. It's like a brand new car. As soon as you drive it off the showroom floor, it plummets. The value plummets. They want you now. So consider that before you sign that contract. And then as a practical matter, right, is a principal who absolutely refused to negotiate and demands that you accept their unilateral terms, however unfair they are. Is that really a relationship that you want to be in? All things to consider before we get started, right? All right. Another form of negotiating, of course, take a look at this contract. This is a fairly standard provision. This is well, we see this quite a bit, these kind of terms, and there's nothing really new here under the sun. It's a standard 30-day termination provision. What the sales rep did in this case is he saw that provision and he decided he wasn't going to have a 30-day provision for any reason. So he crossed out the word without, as you can see, changed the contract. Those are the rep's initials, where he circles his initials and sends it back to the principal. You can see the principal did not add its initials, accepting that particular change, as perhaps the rep intended when he left room there for another set of initials in that circle. But what happened? The principal then co-signed the agreement. The rep made this change, signed the agreement, sent it back. The principal then signed it on his side of the ledger and sent it back to the rep. So a big part of the fight, and this did go to court, was whether or not this change was effective. And the principal certainly sought to escape, saying we had the right unconditionally, we didn't agree to this change. But the court in this case, after a lot of briefing and a lot of argument, the court accepted that by signing the agreement after the rep made this significant change, the principal accepted the change to the terms. By signing it and sending it back, this became part of the agreement. And as a result, effectively, the rep had negotiated out of the agreement through this change the right to terminate for any reason. And instead, termination only existed if there was good cause to terminate. So this isn't necessarily the recommended way of negotiating a deal, but it is an effective way to do it, to try to implement changes. Now, one of the biggest, if not the biggest, term that has to be looked out for upon receipt of a contract, and what you have to know going in, is whether you're going to have an exclusive right to represent the principal in the territory or as to the specific accounts that are being assigned. This is a common non-exclusive provision. This says that you are authorized to represent the principal on a non-exclusive basis. Now, this may be acceptable. This is how many contracts are written. You just have to know this going in. You have to know all of the implications of taking a non-exclusive representation. And you have to consider, and obviously the factory has to consider, well, just how much energy is a rep going to devote to beating the bushes in a territory where there are other representatives in that same territory, or other representatives who can call on the same account, or the factory can call on the account and essentially compete with its representative. Does this make good business sense? In some situations, perhaps it's acceptable. It's obviously not the preferred way to go. The preferred way to go is having an exclusive. If you're going to devote your efforts, your energies to this line, you should be able to do it without having to look over your shoulder as a rep, wondering who else is trying to get in there on behalf of the same factory selling the same product. And there are all kinds of good reasons for this, of course. You know, I mean, we talk about this in front of juries a lot of the time when we go that far. I mean, the point is that you know, and I ask juries sometimes at the beginning of a trial, I say to them, you know, well, you're talking about an independent rep, right? An independent rep, and you all know this, an independent rep doesn't get a salary. An independent rep doesn't get an expense allowance, doesn't drive a company car, doesn't get an office or a secretary, and of course doesn't get paid unless there is a sale. So all of the expenses, all of the beers that have to get bought for a purchasing agent, all of the gasoline that goes into the car, all of the airfare that gets spent, all of the unsuccessful sales calls are all on the sales rep's nickel. And there's no assurance that any of those visits will ever result in anything, or the rep will ever get paid a thing for those visits. It's only if the rep is successful that there is a chance of getting paid. Who would take such a job? Who would do that? Who would agree to those terms? Well, the only way it works, the only balancing of the equities comes if in a situation like this, you have an exclusive territory and you're going to get paid on all of the sales into the territory. Whether you made them or not, you don't have to worry about who you're competing with in a situation like this. If they want to pay you a salary, if they want to cover your expenses, that's different. Then they can send whoever they want. But if you're only getting paid on the come, you shouldn't have to be looking over your shoulder. That's why this language, this exclusivity, is so important. You're going to get paid on all of the sales. And you see this language here, it talks about, it's a little confusing, right? Because it has brackets, and the brackets only refer to whether the basis for the compensation is on a territory or on assigned accounts. Where does language like this come from? Some of you may ask. Where do you get language like this? Well, I'm happy to tell you that this provision, and many of those I'm going to show you today, all come from the IHFRA website. There is a exemplar rep contract that's available to members on the IHFRA website. And many of the provisions I'm going to show you come directly out of that contract. Now, it's not exactly a form contract. It's not the kind of contract you just print out and use. It is something that has to be tailored to each situation. But we've put many strong provisions in there, and we'll go through those. This is one of them. This is a fine exclusivity provision, and it's something that works in most circumstances. All right, now, another, obviously, some would say more important provision, of course, deals with the right to commission payments. And there's different ways to go here. There are different approaches. Take a look at this provision here. This comes from a manufacturer's contract, and it provides that the only compensation to the rep will be on products that the sales rep solicited. The sales rep actually had solicited, not necessarily all sales into the territory. So you're contemplating a non-exclusive relationship here, which, as you know, is not preferred. So you have to show that the sales rep actually solicited the business, and payment's only going to come when the company itself is paid. Again, a not uncommon provision, but not necessarily the safest or the fairest approach. What do I mean by that? Take a look at what the IHFRA contract provides. What this says is that the rep is going to get paid on all orders for products shipped to customers in the territory. Again, it doesn't mean that the rep's fingerprints have to be on it. If you have an exclusive territory, the entire territory is yours. And commissions are earned. Now, you notice how it doesn't say paid, but commissions are earned when the company accepts an order. Why? Because that marks the point when the sales rep has done its job. By generating the order and by tailoring it so that it's acceptable to the principal, and the principal accepts the order, there's nothing more the rep can do to earn the commission. Everything else is out of the rep's hands. But if the rep generates the business, creates the demand, is able to place the order, is able to get the customer to place the order with the principal, the rep has done its job and has earned the order. It may be that payment comes later, as you'll see here in the specimen contract. There's more time provided here for payment. But when the rep has performed 100%, the rep is entitled to compensation. Now, if you have to compromise in the negotiations, and you say, okay, maybe payment will only come when the product is shipped, all right, at least that too is more acceptable than forcing the rep to wait until payment is received by the principal. Especially if there's a provision in the agreement that says, the rep only gets paid when the principal receives 100% of the payment or all of the payment. That means the principal might get a check for 90% of the payment, and the principal is satisfied, or at least is paid in large part, and the rep gets nothing because full payment hasn't been received. So we try and balance these out. We try and look for fairer ways to do things. Another important provision, of course, relates to the definition of order. Since we're talking about order here, how is order defined? And there are different ways to define order. I'm sure many of you have seen that, but we wanted an expansive definition. We wanted to include all kinds of orders. I don't want to get into more fights than I already have with principles about what an order means. It should cover virtually everything. So that's the intent, and that's the purpose of using a broader definition of order, because all of these are generated by the rep. So let's assume for a minute that you've negotiated all of these good terms into the contract, right? You have an exclusive territory, you've set up a fair payment schedule, you have a good definition of order that you're using. Well, what can happen then? Well, unfortunately, if you're not careful about what the contract says, it can still hold the door wide open for you to lose all of those benefits that you have successfully negotiated in. And this provision is not uncommon. Talk about your commissions, but then there's language in here that says essentially that the terms can be updated or modified, essentially changed or taken away by the factory at any time. All they have to do is give notice. So you may have won, at least you appear to have won the negotiation process, but then a provision like this allows all of that to be stripped away in the factory's discretion. That's not scary enough. Let me scare you a little more. There's a section in most rep contracts that talks about the rep's duties under the contract. This is ordinarily a non-controversial or a benign provision that should call for the rep to exercise its best efforts to promote sales in its territory or to the accounts that are specified on behalf of the principal. However, there have been contracts that have essentially gotten to the point of being oppressive. Take a look at something like this. Again, I'm not making this up. This came from a rep contract that the rep actually signed. Look at what the rep is charged with under this provision. I see many of you shaking your heads. This kind of outrageous provision is obviously not designed to promote a healthy relationship, and obviously it didn't work. The relationship didn't last terribly long. But calling on the rep to engage in this kind of sales calling is just silly. And it's another reason I tell you the first two rules of this process are to read the contract. All right, let's go in another direction. Accounting. This comes again from the IHFRA contract. It's oftentimes an underappreciated term in rep contracts, but you can't be expected as a sales rep to take the principal's word for what the sales have been. No matter how good the relationship is, no matter how long lasting or how trusted the relationship is, you are entitled to an accounting. It is a basic right, just as it is with any contract. Never mind a sales rep relationship. In any contract, you're entitled to see for yourself what you're getting paid on, how this is going to work. So I can't tell you how many rep contracts have no provision whatever for an accounting, where there is no right for the sales rep to see what the sales have been. There's no responsibility on the part of the factory to let the rep know what the sales have been. All the rep gets is a commission check or a wire transfer and no paperwork that goes along with it. And apparently the rep is expected to just trust that all the sales have been proper. So you want to make sure you negotiate in a fair provision calling for a accounting to be made to you on a regular basis. And the accounting should be for all sales, including POS sales. So there are provisions to this effect in the IHFRA form contract, the specimen contract. Now, I know another big area that I have been asked about and that many of you have faced involve house accounts. This is something that we deal with on a regular basis. It is a danger to most sales reps. Provisions like this are unfortunately all too common. A provision like this is essentially incompatible. It's fundamentally incompatible with the rights of a sales rep and also the basic rules of contracting. Again, you have negotiated for your territory or for your accounts. And once you sign on the dotted line, of course, you're motivated to do everything you can to build up that business and to strengthen either an existing account or to develop a new account and make it as productive as possible for the factory. But if you have a provision like this in your agreement that enables any account that you develop to be taken away, usually it's again on 30 days notice, something like that, it is a basic crime for something like this to be permissible. The far better approach, of course, is to require some consideration coming back to the rep if you have to accept any kind of house account provision. It can't just be taken away to the point where the relationship is no longer viable and a significant chunk of the income associated with this account is gone because there's a provision like this. This is another approach. There's two problems with this house account provision. The first problem is it says the commission, talking about commissions, the commission shall apply to all orders solicited by the representative. Again, reps shouldn't be required to get paid on only orders they solicit. I know it's not uncommon, but if you're negotiating, this is an opportunity to make sure that you have an exclusive territory and you're getting paid on everything. But the second part of this is it says the manufacturer has the right to add additional protected accounts from time to time. Here it's called a protected account. So even though you start out and you see here where it says in the middle, no commission shall be paid on sales to the following specified accounts, and it says none. So when you begin the relationship, you're feeling good. There are no accounts that are off limits. But by adding this last sneaky sentence into the contract, where they reserve the right to add additional protected accounts by sending notice, you're giving them the keys to the castle. They can take away anything that you have done by sending notice. Obviously, there are better ways to go. This is a much fairer approach. This speaks to the idea that if there is a condition that changes such that an account needs to be considered a house account, it has to be negotiated. There has to be valid consideration. They can't do it unilaterally. These kind of unilateral changes strike at the heart of the whole relationship. But if there's consideration that the rep accepts, then it can be taken away. And here, this is the language now. You'll see that the actually is used in the IHFRA contract. It specifically bars. At no time during the term of the agreement shall the company, without the rep's written approval, take away accounts. That's in the form contract. That makes solid business sense. It doesn't say that accounts can't be made house accounts. It says they can't be made house accounts without the rep's approval. From a business perspective, it has to work for both ways. After all, a successful principal rep relationship is a partnership, and it has to make sense for both sides. This is the way partnership should work. It is the way house account provisions should be dealt with. Another area that we get asked about quite a bit these days is reporting. It seems that principals are requiring greater reporting from sales reps. And sometimes you see provisions like this. asking for all kinds of reporting to be made. There's all kinds of reasons to stay away from provisions like this, to avoid having to make reports on a regular basis. But this provision is especially oppressive, right? You need to submit quarterly listings and to furnish data on potential customers. I mean, you know, you're giving away everything if you sign a provision like this. But think about all the reasons not to go into something like this. And it applies, you know, to manufacturers as well. Reps are independent contractors. It's important to both sides that they maintain that independent contractor status. You read about this from time to time. California has gotten especially aggressive in the independent contractor regulatory business. It applies to Uber drivers and so forth. But one of the things that the IRS looks to in deciding whether a individual or a business is an employee or an independent contractor is the idea of control and of having to report. And if you have to make this level of reporting, the kind of reporting that's ordinarily associated with employees rather than independent contractors, this provision could very seriously damage a manufacturer's ability to avoid the tax obligations that are associated with employees. So it really isn't in a manufacturer's best interest to insist on this level of reporting. But as a practical matter, you know, reps are supposed to be out in the field selling, right? You're not supposed to be at a computer, at a desk, filling out reports, sending information in, and you're certainly not reasonably expected to give away your intellectual property, your private confidential information about prospective accounts, the way some kind of a requirement like this would call for. So this is just abominable. And here it is. You get to go more requirements, going from bad to worse, you know, asking for all of this information. All this comes from real rep contracts. I'm not making it up. This is stuff that has been required in certain relationships, and it's awful. And I can't advise well enough to avoid these kinds of requirements. Now, look, most of what we deal with, most of the provisions that we get involved in, unfortunately, come after trouble has arisen, not at the front end when a rep comes to us and asks us to help them rewrite or improve a contract. That's obviously the preferred route. But usually what we see is a situation where there has been a termination. And that's when everything heats up. So that's when, for the first time, oftentimes, reps look at the termination provision to see what rights they have when a factory wants to make a change. And you see a provision like this, very common, talking about when it commences. But then you get a provision that says, upon termination, commission shall be paid on purchase orders placed and shipments made up to the effective date of termination. So a provision like this, if it's in your agreement, means you can rep this line for 35 years. You get a notice of termination, 30 days notice of termination. That's all you're ever going to get. Never mind that over those 35 years, you have developed the territory, you have found all kinds of new business, you have created the demand for the product where there was no, perhaps it was a virgin territory, there was no product before, there was no factory recognition before. You provided all of that, you introduced and developed it in the territory. And of course, the customers that you put together with the factory are going to keep buying into the foreseeable future. But with a provision like this, you have given away your right to lay claim to those commissions into the future. I don't know if any of you were on the last seminar or webinar that we did in connection with legal rights, but one of the things we talked about was the procuring cause rule, the ability to go after post-termination commissions based on your pre-termination efforts. And that right does exist in many states, unless there's language in the contract that blocks it. This is the kind of language that would interfere with your ability to get paid commissions post-termination on the work that you do pre-termination. So naturally, we have a better suggestion for you. Well, here, first, let me show you another section of a contract that came up. This says that upon termination, the company can in sole discretion cancel the rep's entitlements to all or a portion of the commissions that are payable. So this is even worse. This says, even though it appears to say you get 90 days post-termination commissions, because it says following the effective date or expiration for 90 days, it says the company can in its sole discretion cancel the rep. And it also says if the company determines that fairness requires all or a portion of commissions to be paid as comp. So your right to receive 90 days commissions isn't open-ended. It's not for sure. It's only if the company determines that fairness requires it. So again, this is the kind of, it's an unusual provision. It's not real ethical for me, as far as I'm concerned, to have this in here. It doesn't speak well to a principle that would put this kind of language in here. But as a practical matter, you're again giving up your right to post-termination commissions unless the company is in love with you, which they probably aren't because they wouldn't have terminated you in the first place. So these are examples of provisions to stay away from, of course. Now let's get to a better approach. This is not language we drafted. This is language that we were presented with. But look how favorable this language is. I know it's hard to read this, so let me summarize this. There's 4 clauses in here that are relevant. It says that commissions are paid on all orders procured by the rep before termination, regardless of when they're shipped. If the shipment is made as a result of the rep's efforts, they're commissionable. It says that commissions on all orders received by the manufacturer and procured by the rep for 1 year after termination are commissionable. So again, the order isn't in-house at the time of termination, but if it's in-house within 1 year after termination that arose from the rep's efforts, then they're commissionable. It also says you get commissions for 3 years on reorders. Very important provision. I think it's reasonable and fair. I don't see this nearly enough, specifically dealing with reorders. There's no more work that a new rep has to do or a factory has to do, except perhaps to answer some basic or administrative questions. These are reorders, meaning you've already done the work while you were the rep. So here's an opportunity to step in and get paid for that work for a reasonable period of time. And it says that you get commissions on custom orders, the design-ins that you procured while you were the rep for the life of the part. Think of all the work that was involved in getting a special custom order. Wouldn't have happened without you. You should be entitled to those commissions for the life of the part. Very unusual contract, but a very good one for the rep. Now, we know that not every factory is going to be willing to pay post-termination commissions for 3 years or for the life of the part. So the specimen contract that's available to you as IHFRA members provides another approach. Frankly, I prefer the previous one, and it's up to you to try and negotiate that in. But if you can't, this is an alternative approach. Here, unless it's terminated for a breach, the commissions on all orders received by the manufacturer for shipment into the territory you get commissions on those orders for 90 days following the end of such remaining term of the agreement. But you're also going to be entitled to receive commissions on orders for products procured by the rep prior to termination and received by company after termination for the life of the part or the program. Again, tied in directly to your work. This is not always easy to get either. I understand that. So another approach provides something that perhaps is another compromise approach, that you're going to get commissions dated or communicated prior to the effective termination. But if you serve for at least 1 year, if you make it through that first year, your rights go up. That if after the first year, there's an agreement in this provision to pay the rep a termination fee equal to 1 month's average comp. So you look at back what the average comp was for the previous 12 months, whatever the average commissions were, you get that provision multiplied by the number of years the agreement was in effect. So if you are the rep for 20 years, you're not just unceremoniously kicked out the door and said, we'll pay you for 30 days. You could at least get the number of years times the average monthly commission salary, something that at least comprises a fair separation provision. Something like this at least is better than what you typically see in these agreements. All right, we're going to move on to the next subject, which is a subject that is certainly worth fighting over: post-termination non-compete agreements. I want to believe that none of the IHFRA members would sign a rep contract that has a provision like this in it. Here, the manufacturer was insisting that for the privilege of representing our line for however long we decide to keep you as our representative, you agree that you will not represent a competitor for 2 years after you represent us. So we can terminate you and then sideline you for 2 years. Think of all the bad language in this one sentence. Not only is it a 2-year provision, but it doesn't say who gets to decide what competition is, what competes with the principal. So the principal, of course, is going to construe that as broadly as possible as to any company that does business comparable to their business. What if you're not involved in representing the actual product that is competitive with what you were representing the first principal for, but the company sells that product? The principal may well say that's a competitive business, they compete with us, and therefore, even though you're not directly involved, you can't do that under a provision like this. There's only one way that I ever advise a rep to agree to a post-termination non-compete provision that's even 1 day. You should not be prevented from plying your trade unless the principal is willing to pay you for that period of time when you will be sitting on your hands. Otherwise, this kind of approach is basically antithetical to all things sales rep related. You should never agree to a post-termination non-compete unless the principal makes it worth your while. Here's a provision that perhaps doesn't get all that much attention, but most of these agreements that are drafted by the factory will include a dispute resolution procedure that is, is somewhat unfair or perhaps even inappropriate. Some rep agreements provide that in the event there's a dispute, you're going to have to go to arbitration, which is not uncommon, but I don't prefer it. I prefer being able to go to court, of course, where their rules of evidence apply and where there's an opportunity to take an appeal in case a judge is, making some mistakes. But here you're talking about in this provision, rules of arbitration by the International Chamber of Commerce. So you're not even necessarily dealing with lawyers or judges here. You're dealing with Chamber of Commerce, who are usually very conservative, usually come from the manufacturing community or at least a business community, very different from a sales rep. So it's kind of a stacked deck here. If you sign off on something like this, why not go to an arbitration provision that's far more acceptable or far more common than the Chamber of Commerce, which is stacked against the rep? And then the last sentence here is actually, I think, from a different agreement, but it says that if there's an arbitration, it shall be in Connecticut in accordance with the procedural rules of Connecticut. Well, the rep in this case was in Florida, and he's now agreed that he's going to fight in Connecticut. Again, a better approach is to try to come up with something up front that recognizes a negotiation process. Why should you have to go to Connecticut? Why shouldn't it be in Florida? At least try and negotiate something in up to at the very beginning. Make sure you're not going to some forum that is designed to be less favorable to you. Make sure if you're dealing, for example, with a foreign manufacturer, it doesn't say that any disputes have to be brought in Norway. You want to be able to bring the suit here. You want them to stipulate to the jurisdiction of the courts here. These are all provisions that can be very important to you. Let me just quickly go through some other important considerations. Most of these agreements drafted by factories have a choice of law provision, again, similar to the venue provision, but not the same. It says that, if the principal is from, let's just say, Florida, then Florida law will apply. Well, there's dangers associated with that. If the rep is from Ohio, of course, you would prefer Ohio law to apply. But among other problems with this is most states, as many of you know, have sales rep protection statutes. It's not part of this presentation, but there are protection statutes that work to try and level the playing field between a rep and usually a much deeper pocketed principal. And Florida is a state that doesn't have a Sales Rep Protection Act. They had one years ago, but it was repealed. So if it calls for Florida law to apply, it's going to be much more difficult for the sales rep, and you want to know this going in. You also want to know, if you can, that you have a chance at recovering attorney's fees in order to make it more worthwhile for the rep to consider taking on this battle in the first place. Something that we talked about before, you want to make sure that you maintain your independence, that the contract doesn't do anything to take away your independence. You're not getting the salary. You're not getting a company car. So if you're going to get paid like an independent contractor, meaning only on sales that are made, you want to make sure your independence is preserved. All that's part of the contract. Some contracts provide for non-solicitation provisions. You may have seen these before. Somewhat similar to the non-compete provision we talked about earlier, where it may say that if upon termination, the sales rep agrees not to solicit any of the principal's employees to join the rep firm for the next 2 years, something like that. Those provisions aren't necessarily terrible. My advice there, though, is they always need to be bilateral. It should be fair. It should be reciprocal, where the principal also agrees not to solicit away your people for 2 years. You have a key man that they love and might want to, lure away to come work for them directly. So you want a provision that says we're going to make it reciprocal. Neither one of us can solicit the employees of the other. That's somewhat like, provisions that talk about indemnification. Usually a principal wants the rep to indemnify the rep from any actions that the rep takes in the course of the representation that may come back to adversely affect the principal. And again, those are not necessarily unfair as long as the indemnification works both ways, and the rep too is indemnified from the manufacturing process or other possible problems caused by the factory. So then we get to split commissions. Most of you are familiar with split commission provisions. There's nothing wrong with split commissions per se. I don't even object to split commissions being settled by the factory. If there is a question of how the commissions are going to be split among sales representatives, it's not inherently unfair to say that those decisions shall be made by the factory in its discretion as to how to allocate the split. What I do object to, and what is unfair, and what I have tried cases over in the past, is when the principal takes the position that, well, we don't have another rep in the other territory where there might have been a split, so we keep that section. We keep that split for ourselves because there's no rep to give it to, no other rep to give it to. And of course, that is not a split commission. That is a reduced commission if they're going to keep it for themselves. So the general principle here is that split commissions are never split with the house. I could talk longer about all of these, but I just wanted to make sure I mentioned them in an effort not to overwhelm here. Okay, I know there are going to be questions, and I invite those questions. maybe the best way to do it, Steve, is to do it through the chat feature.
Sure.
I mean, if you want to do it, by unmuting somebody, that's up to you. We can handle that. I know, Ray, you may have some questions after listening to this, so I wanted to leave time before everybody gets bored and fades off with the opportunity to ask certain questions about any of this. And I know there have even been some COVID-related questions. I'm happy to take those as well. So let me turn it back over to you, Steve, and we'll proceed however you'd like.
Sure. Well, like I said, I know my more experienced partner over here has got some questions. So I'll let him kick things off while they come in chat, if any do.
All right, thank you both. My only gripe with this webinar is I got writer's cramp. I got writer's cramp, Adam. My God, I didn't realize the subtleties, how dangerous these subtleties can be, and the wording, these little parenthetical phrases that can make or break. My first question, and this is kind of from a 500 foot aerial view. You and your firm successfully represent reps across the board, totally different sectors. Are the contract issues similar across the board, regardless of industry, whether it's consumer electronics, housewares, furniture? That would be part A. And part B, is it your sense, and this may be an unfair question, my sense is that our group, the furniture reps, probably operate with a much lower percentage of written contracts than other groups. And I don't know if you could respond to that.
Yeah, of course, and I am familiar with the high degree of oral contracts that permeate this industry. It's higher than most other industries, to try and combine the two questions. Well, first of all, let me tell you, Ray, the issues that arise in connection with the furniture industry are largely the same as I see in other rep industries. We are counsel to a number of rep associations. We speak at a number of rep conferences. We do webinars for a number of groups. I did one yesterday for the electronics reps, largely on COVID-related questions. But the issues that we see are comparable in terms of the ways that sales reps get treated and the efforts that are made to terminate sales reps without paying them what they are owed. Most of the form contracts, or not the form, but the individual contract languages that I showed you today do not come from the furniture industry. And yet you can see for yourselves how applicable they are to the situations that many of you have faced. So we do see a common issue that arises across the industries with respect to how reps get treated and the importance to have carefully tailored contracts, or at least negotiated contracts. And as to the second question, oral contracts are enforceable in all 50 states. Nobody ever doesn't have a contract if you are a sales rep. I get calls that often begin, Adam, I didn't have a contract with this company, but this is what happened. And I always pause and say, you did have a contract. You were making product sales in exchange for an agreed upon consideration amount, an agreed commission rate, or some other agreed compensation. That is the makings of a contract. And what I tell reps all the time is that I would much rather have an oral contract than a bad written contract, because an oral contract does make many more remedies available than a one-sided written contract that limits the sales rep's rights. So even though this presentation today was, of course, about written contracts, because it's very difficult to specify how oral contracts should be negotiated, except that once you reach an agreement, you do want to try to capture that agreement and confirm it in an email. But there's nothing wrong with oral contracts, and I'm not here to tell you that you can't make new oral contracts, or that you have to quickly try to reduce your current oral contracts to writing, because I know how impractical that is. But in terms of developing written contracts, the tips that I try to offer here should help in coming up with a fairer written contract.
Thank you. Steve, I want to leave time for questions from the group.
Yeah, so I know if that's Neil, how do rep agreements work if you are a rep, if you rep an international company doing business in the United States?
The question is I heard about it.
How do rep agreements work if you rep for an international company, but you do business in the United States? Like I used to work for a Chinese company, for example, but I was based in North Carolina, and that was my area.
Yeah, well, it's a very common situation, of course. A few points. Here is where the venue issue and the choice of law issue that we talked about briefly are more important. If there is a foreign manufacturer, you do want to make sure that the venue provides that any disputes will be resolved in the United States, in preferably a territory or a jurisdiction close to where the rep is located, convenient for the rep, assuming that that jurisdiction has favorable sales rep law. And the laws vary in the different states, but you don't want to have to go litigate overseas because it's rarely going to prove worthwhile and it's very difficult to do so. So you want the rules of the US to apply to that relationship, both in terms of venue and the choice of law. And if you do that, if you have a stipulation that they agree to litigate any disputes in the United States, then it's comparable to a domestic dispute because the contract provisions will govern and the standards and the norms will be applicable from the United States, from the rep's perspective. The larger question and the more difficult issue usually comes up in terms of collecting on a judgment. If the case does go to trial, just because the principal has agreed to litigate in the United States or to arbitrate in the United States, doesn't mean that they have the ability to collect on a judgment, when you obtain one. And it's very, very difficult to collect on a Chinese defendant. Certain countries are parties to treaties or conventions that are expected to make this easier and allow a US judgment to be enforced overseas. But even for members of the Hague Convention or other international treaties, it's still very difficult. What you want to look for, and what we always do, is to try to find US-based assets that the international company may have. It doesn't necessarily mean they have to have bank accounts in the US, but for example, if they have customers who are buying product from overseas and sending the payments to the company overseas, that is a US asset. And if we get a judgment, we could levy against that US company so that the payments that are coming into the future for product could go to satisfy the judgment rather than back to the Chinese principal, say. So there are different issues associated with foreign companies, but if they have assets in the United States, and if they agree to litigate here or arbitrate here, it's generally doable.
Thank you.
So we had a couple of questions come in, and we've had several questions come in, but we've had a couple come in regarding, reasonable expectations that are set by these factories. So, about, manufacturers ask, what can they ask for as far as reports? We have, one question was, I apologize. There's been quite a few, but basically saying like they're asking for X number of reports to be provided this many times throughout the month, or I'm a 1099 employee, but I'm being told I have to work at a dealer's work a dealer's floor on the weekends as well. So just again, it kind of boils back to the responsibilities of a rep, whether it be reports or how they spend their time or this or that, but what rights do the reps have, or do they just have to do it, or for fear of repercussion or punishment or termination? What advice could you give them in those types of situations?
Well, Steve, as you know, if you may be getting paid like a 1099, but if you are being told when you have to work and where you have to work, and you have to show up when the factory calls, I'm not sure the IRS would consider you to be a 1099 employee, a 1099 worker. You sound a lot more like a W-2 if you have to jump when the factory snaps. So the arrangement isn't favorable, I don't believe, for either side in that situation. You want to maintain your independence, and as you heard me say before, the factory shares that interest, and the factory should also want you to maintain your independence and recognize that they're walking a dangerous line if they decide to tell you when to show up, and if they give you orders to follow, and you don't have the ability to call on customers or to lay out your own strategy as you see fit. You have to do it based on directions issued by a factory. Those are issues of control that are very likely to have the IRS and perhaps some state agencies as well. California is just one example, to take a second look at how you're getting compensated and whether or not you're due additional benefits as a result of your status with the factory.
Okay. Let's see. And just out of curiosity, and I know we probably can't get everyone to respond to this, but just out of those on the call, how many of you actually have a written contract? I'm just genuinely curious. I know we talked a lot about how we have a lot of oral agreements. Anyone out there that can tell us that they actually have a written contract? Yeah. So we've got some.
That's an interesting question there about the healthcare.
But also, so again, we've had several questions come in. I want to try to make sure we get to all of them if you have.
And Adam, how much time do you have? We have a couple of questions. Do you have time to take a shot at them?
Yeah, I can keep going for about another 10 minutes.
Okay.
Let's see. What about a clause that says you cannot represent other lines that have non-competing products, but if they find out that you have another line, they say your bag is too full to have another line, and they do not allow you to leave the showroom at markets.
All right. The first part of that question was to say you're not allowed to have.
So it says they have a clause that says you can represent other lines that have non-competing products, but basically what I think they're asking is when they find out that you have other lines, you're told, hey, your bag's too full.
You can't leave the showroom during market. You have to stay in our showroom.
Okay. Well, part of that is perhaps legitimate. I mean, if you are, it is a principal's right to judge whether or not they're getting the proper level of care and attention from their sales reps. And if they feel that you're being, taken in too many different directions, you're not giving their line the attention it deserves, then perhaps they can make a change. Doesn't mean you're breaching the contract. It just means that since the contract probably says they can terminate for any reason or no reason on 30 days notice, it means they may exercise their right to make that change. But of course, nothing speaks louder than sales. So if your sales dollars are there, if you are producing the revenue that would support keeping you as the sales rep, then again, the factory shouldn't really care very much about how many lines you carry or how much, other business you're generating for different principals. As long as you're satisfying them, as long as your numbers are good, that should be the preeminent factor in deciding what to do with you. But if your numbers are down and they see that you're also representing what they consider to be too many other lines, that is a legitimate business reason to consider making a change of sales reps.
Good. We've got time for one more with Adam's schedule. I am intrigued by this healthcare question.
Sure. It says there's a clause in my contract that states I need to provide health insurance for my employees. If my sub rep is considered an independent contractor of my company, does that exclude me from this provision? So if I, the self-employed, independent contractor, have an employee that's also a 1099 independent contractor, am I excluded from that?
All right, well, forgive me for answering that like a lawyer, but it really depends on the language that we're talking about. Here you're talking about a principle that is, for some reason, protecting your own employees, right? Wants you to make sure and pledge that you're providing health insurance to your employees, the members of a independent contractors organization. Okay, but I understand that's not part of the question. The question is, assuming that is the requirement in the contract, does that apply? Does that reach to folks who are not employees of the rep, but rather sub-reps. And ordinarily, it would not, but depends on how the language is phrased. If the principal is such a big brother type that the language in the contract says, all those associated with you or anybody who may call on customers on our behalf, then it might reach the sub-rep. It really depends on the specific language in the agreement.
Okay. I just want to go back to a question that was asked, gosh, probably 10 minutes ago now, but I didn't quite get to it. Is there any statute of limitations on let's say, a termination agreement where they said you're supposed to get paid X, Y, and Z, but this was, say you were terminated from that line 2, 3, 4 years ago, and they didn't do right by you, but you still have that agreement, you find it. Can you go back and pursue anything, or is there a statute of limitations on that?
Well, the answer is yes, there's always a statute of limitations on a contract action, but the statute of limitations varies in all 50 states. So there is no federal or uniform statute of limitations. In Illinois, the statute on a written contract is 10 years, but the statute for an oral contract is only 5 years. Many states have shorter statutes for oral contracts. Some have the same, but others have shorter contracts, shorter statute of limitations for oral contracts. The reasoning being, the thinking behind that being that memories fade, that it's hard to recall events, that it's much more difficult to present in court witnesses who can testify about the terms of an oral contract after a certain period of time. Whereas if it's recorded in a document, if there's a contract that reflects the party's agreement, it's fair to say you can have a longer period to bring your claim. So it all depends on where you're located as to what the statute might be. You can certainly inquire of me afterwards. If you want to send me an email, I can speak to you about how long a statute of limitations may be applicable. But again, it doesn't just depend on where you're physically located. It depends on what your contract says. If your rep contract, assuming it's a written contract for a minute, says that the law of Minnesota applies to your agreement and you're located in Arizona, you have to look to see what the statute of limitations on a written contract is in Minnesota. And I can certainly find that out for you. But it's something that is very important. You can't bring even if you've been screwed out of commission, say for a multi-year period, and you didn't learn about it until much later when you found out all of these additional sales were coming in and the principal didn't report them to you, you may not be able to seek to recover the entire period of time for which you have been shorted commissions. But if it happened over 8 years and the statute of limitations is 5 years, maybe you can't recover for the first 3 years of that period, but you could still recover for the more recent 5-year period when you were unfairly treated.
Okay. And I apologize. Selfishly, I've got one more question, just because
if Adam has
if you
time.
of course, if you have the time, Adam.
Of course.
A lot of what we talked about today assumes that you either have an oral agreement or a written contract in place, and you're already working that territory. But is it ever? When would it be is it ever too late to try to introduce a new written contract? Can you go back to your factory 6 months after starting, your new role as an independent contractor for them and say, hey, I really think we should put a contract in place?
The answer is clearly it's never too late. There's no prescription on doing that. There's no limitation. It all depends on the relationship you have with the house. If they're willing to consider it, then perhaps they will entertain that notion. It may be to their advantage to reduce the agreement to writing, to get you to agree to certain terms that perhaps they didn't think of when you first signed up with them 6 months ago or 6 years ago. But obviously, if you're already engaged in the relationship and you're already selling their product and presumably you're already making money for them, they may have less incentive to change the relationship after the fact. If things are going well for them, they may say, why rock the boat? And why would they then later agree to a written contract that perhaps is going to tie their hands a bit more than when they were successful in getting you to agree to an oral contract in the first place? So again, it all depends on the individual situation, what you're trying to accomplish. By by reducing the contract to writing at that point, the nature of your relationship with the principal, and whether you're going to be sorry if you end up with a written contract, because it may have a lot of terms that you were better off not agreeing to in the first instance. So, you know, it's going to obviously involve a number of considerations.
Got it.
Adam, on behalf of everybody, the fact that so many people are still on this call really just underscores to me how important this information was and useful. On behalf of IHFRA and everybody still on the call, I want to thank you for your willingness to always help us out. Thank you for the wording of the sample contract that's on the website. Clearly, we could do none of this without you. Everybody on the call, read those contracts twice, 3 times. When in doubt, seek good counsel. Don't call me, I'm dangerous.
Okay, well, thank you for having me, Steve and Ray. I enjoyed it. A lot of good questions from the group, which I expected. And if you need me, I will be available to help out on other questions.
Perfect. Thanks so much, Adam.
Thanks, Adam.
Bye-bye.
Thank you, everyone.